I begin by acknowledging the traditional owners of the land from which I make this presentation and the traditional owners in the lands in which this presentation is received. I thank my associates, Tao Bui and Madeleine Leson, for their assistance in preparing this presentation, of course under pressure of time. When we decide parenting cases, we do so knowing that if something goes wrong, the parties can come back to court and you or a colleague will look at the case again and fix it. But with a Hague return case, you're sending a child back to a country with which you are probably not familiar and into a legal system about which you know very little. For Australia, which is remotely located to all contracting states to the 1980 Convention apart from New Zealand and Fiji, this tyranny of distance serves to magnify the apprehension which courts customarily feel for the return or relocation of a child over a long distance. In 1995, a majority decision of our apex court commented that the appropriate implementation of the 1980 Convention entails a preparedness on the part of each contracting state to exercise a degree of self-denial with respect to its natural inclination to make its own assessment about the best interests of children who are currently wrongfully in its jurisdiction. Hague work requires a clarity of thought, courage and forbearance on the part of the requested judge to defer decisions about what is in the best interests of the child and return the child to the country from which the child has been taken or withheld. Concentrating Hague work amongst a small number of judges is best practice, but those of you who then do this work will find yourself writing decisions late into the night to meet deadlines. You'll find that your non-Hague colleagues won't understand the intricacies of the work or your reliance on international authorities that appear to run counter to a decision that they would make in a usual parenting case. It can be lonely work. So there are several principles for good practice under the Convention. Experience shows that the Abduction Convention is most effectively implemented within contracting states, which concentrate the jurisdiction to hear cases to a limited number of judges in that jurisdiction. I congratulate you on deciding to concentrate Peru's jurisdiction to hear Hague return cases. You will find that there are many benefits. Judges can acquire specialist knowledge on the 1980 Convention. Hearings can be allocated much more quickly. Matters can be case managed robustly by the judge from the very beginning. Judicial education can be delivered efficiently and effectively. Recent decisions from other contracting states can be circulated. Judges can be easily familiarised with the operation of the International Hague Network of Judges, which I'll say something about later. Related services such as social science assessments by psychologists or social workers and specialised Hague mediation can be delivered more easily. When concentrated jurisdiction vests in a superior court, the decisions of that court are authoritative and are more likely to be consistent. The decisions are most likely to be accepted by a court in the other contracting state. Finally, there is the ability of a concentrated jurisdiction includes the ability to cultivate expertise within the profession. That is, the counsel who come before you to prosecute cases, defend cases, and have the child's interests represented if that applies in Peru. Concentration of jurisdiction is, of course, not limited to hearings at first instance. It also goes for appeals. Appeals need to be expedited and dealt with by a specialist court, or at least where one judge is specialised in Hague Convention matters. Slow appeals completely reverse and negate all of the work that went into the first instance hearing being expedited and done as quickly as possible. More complications arise in a case when the family is left waiting for a decision under appeal. Indeed, if you can get your appeals on very quickly, and in Australia we try for something between a week and a month at the latest, you'll find that there are much fewer appeals actually lodged because they don't come with the automatic advantage of delay, and taking parents are less likely to want to pay and commit financially to an appeal if they don't get the benefit of some months awaiting an appeal decision. When you come to hear return applications, there's a new language to contend with. Terms like habitual residence, rights of custody, soft landing arrangements, and protective measures. These are special terms which must be accorded particular meaning in order for the Convention to apply across a wide array of legal systems and to bind all relevant authorities, including courts. The terms are often used in other conventions, such as the 1996 Convention, which I would dearly like to talk to you about if I had more time. A wrongful removal or retention is not an unlawful act. The 1980 Convention does not criminalise parents' activities. Contracting states criminalise activities, and indeed a judge with a return application to decide will frequently have to contend with a taking parent who faces criminal proceedings on their return to the state of habitual residence. Not every unilateral removal of a child across an international border qualifies for a return under the 1980 Convention. In order for the 1980 Convention to apply, it must have entered into force between the contracting state that seeks the return of the child and the contracting state in which the child is physically present. The child must be under the age of 16 years. The removal or retention of a child must be wrongful within the meaning of Article 3 of the Convention. Article 15 of the Convention permits a requested state to require a determination from the state of habitual residence that a removal or retention was wrongful within the meaning of Article 3. It sounds good, it sounds effective, but it isn't. I recommend that you do not use this mechanism because it will delay your proceedings and it will probably not give you the result you seek. Most importantly, the determination of the court in the state of habitual residence about wrongfulness of the removal or retention is not binding on you in any event. For the removal or retention to be wrongful within the meaning of Article 3, there must be breach of rights of custody under the law of the state of habitual residence. There must also be the equivalent breach of rights of custody under your law. A wrongful removal or retention are mutually exclusive concepts. Then there are exceptions to return, and I list them in this slide. Each one of these exceptions could fill a day of your conference, but I only have time to identify them briefly. The first exception is if the left-behind parent was not exercising rights of custody, or the removal or the retention was not in breach of those rights. The second exception is that the requesting parent consented or subsequently acquiesced to the removal or retention. Texts and communication between the taking parent and the left-behind parent on social media can be particularly helpful when considering this exception. The third exception is that the return would expose the child to a grave risk of physical harm or psychological harm, or otherwise place the child in an intolerable situation. This covers domestic violence and domestic abuse, including that experienced by the child through the mistreatment of the taking parent. It also concerns the situation that the taking parent, and therefore the child, will face on return. For example, it may be intolerable if the taking parent is not allowed back into the state of the child's habitual residence, where the taking parent has been convicted of a crime in their absence, and although allowed back into that country, will be put into prison immediately on return. This has been my experience with some returns under the return applications to the United States of America, and has resulted in a child not being returned. It would be intolerable, for instance, if a return would also lead to a taking parent who was the primary caregiver before the abduction to disintegrate emotionally or psychologically to the point where the child would effectively lose that parent. There are many other instances in which Article 13b can apply. What is clear is that through 13b, the 1980 Convention has remained current and fit for purpose. The fourth exception I identify is that where a child objects to return and is mature enough to have his or her views taken into account. Obviously, the closer the child is to the cut-off age of 16 years, the more weight is to be placed on the child's objection. Australia has difficulties when dealing with this exception, but that's a topic for another day. Finally, there is an exception that a return would be contrary to fundamental principles of freedom and human rights of the state to which the child has been taken. This is not a frequently used exception. Once a removal is characterised as wrongful, it's necessary to determine whether the application for return has been made within 12 months of the date of the wrongful removal or retention. This should probably be considered even before the other exceptions to return. If a return is filed within 12 months, the return of the child is mandatory and must be prompt unless one of the exceptions that I've just discussed apply. However, if the return application is brought more than a year after the wrongful removal or retention, the child must be returned unless it is demonstrated that the child is now settled in his or her new environment. Please note that the 12 months starts to run from the date of the wrongful removal or retention, and not from the date on which the requesting party became aware of the removal or the whereabouts of the child. Internationally, there is some separation of the interpretation of this provision, and in Australia, if it is established that the child has settled in his or her new environment in Australia, and it was 12 months between the wrongful removal and retention and the filing of the application, it is held that the convention no longer applies and the child will be permitted to stay. When assessing exceptions such as grave risk or an intolerable situation, you should have regard to what conditions can be imposed. In Australia, our implementing legislation enables us to impose such conditions as we consider are proper for the implementation of the 1980 Convention. When considering conditions, make sure that they can and will be implemented. In fact, consider making return subject to preconditions. That is, if a situation calls for accommodation to be provided for a short time, don't order that the left-behind parent provide reasonable accommodation, because there will always be an argument about what is reasonable. It would be preferable to require the left-behind parent to pay an amount of money which can be used by the taking parent to secure accommodation themselves. Frequently, there are arguments about who should pay for the return of the child and the taking parent. Don't stand on principle or let parties stand on principle. I suggest that you make orders that the left-behind parent pay without prejudice to his right to seek to recover the money from the taking parent once they're both in the home state. It is simply a waste of time to get into an argument about whether the taking parent has enough money to pay for her own airfare. Once it is decided that the child should be returned, the court should ensure that the return is effected as quickly as possible. This is why it's appropriate to refer to the mechanics of return early in the first hearing, even at the first hearing date. As network judges in Australia, and to assist other countries in returning children to Australia, we have prepared a fact sheet on how taking parents can obtain orders for the protection of themselves and the subject children prior to returning to the state of habitual residence. Australia presented this to the 8th Special Commission last October, together with a Spanish translation, which is available to you if you click on this link. Hague return applications require robust case management. Please make sure that you are on top of the case. Read the application thoroughly before the first court hearing and make notes and compile a list of questions. Identify the jurisdictional facts or prerequisites to wrongful removal or retention. They are things such as habitual residence, rights of custody, breach of rights of custody. Identify for yourself what exceptions to return may be argued so that you can order any necessary reports or assessments. It is very important to secure the child. That is done by requiring the child's passports to be lodged for safekeeping, and if you can, require the passport of the taking parent to be lodged for safekeeping as well. Restrain the taking parent by herself, her servants, or agents from doing any of the following without the prior written consent of the prosecutor or the central authority. Prevent them from removing the child from the child's current residence and school or daycare facility. Prevent them from removing the child from the state or region in which the child is residing, and obviously your jurisdiction of Peru. Prevent them from having the child examined or assessed by a psychologist or social scientist, because this will compromise the presentation of the child in the event that such an examination is required for the court hearing in the context of an objection to return or an intolerable situation. Require copy orders to be served on other people who are relevant to the care of the child, such as the proper officer of the school or daycare facility. In these circumstances, that will enable the central authority to be able to contact the principal of the school or the manager of the daycare facility to ensure that the child is still attending. Empower the central authority to inspect the child's residence and verify the identity of the child. Also remember to safeguard against reverse kidnap. Reverse kidnapping is when the left-behind parent comes to Peru and either legitimately or by deception obtains possession of the child and then takes the child back to the country of habitual residence. If you have stop orders which prevent the child being taken out of Peru by the taking parent, make sure that that stop order also relates to the left-behind parent. Of course, case management of Hague cases must be robust because there are time limits imposed on Hague return cases by Article 11 of the Convention. Please note that Australia does not routinely meet the 42-day time limit, but we try. At the first hearing, we specify a realistic final hearing date and then overestimate the time that may be required to complete the trial. When dealing with Hague cases, you're generally dealing with a prosecutor who knows how the convention should work and how it should apply, but you will be dealing with a respondent who isn't familiar with the convention and who has probably gone to, or who may have gone to, a professional, a solicitor or a lawyer who is sympathetic to their cause rather than skilled in the authorities and jurisprudence of the 1980 Convention. So they're not going to know what to do with the case. Allow a realistic time in which the requesting parent can respond to the evidence of the taking parent, and the taking parent can then respond to that evidence. As part of your robust case management, press the parties to identify the witnesses in their case and why that evidence is actually relevant to the return proceeding, as opposed to an ordinary parenting case. Article 30 provides that documents sent with an application are admissible in evidence. That only applies to the application and does not enable the respondent to rely on any such documents. Indeed, it's often the respondent who has the difficulty in obtaining necessary documents from the state of habitual residence, so you need to make allowance for that in your timetable. Require the parties to prepare a trial plan and then try to keep them to the estimates in the trial plan. Invite parties to make concessions. For instance, they may concede that the removal was wrongful, and that the real emphasis in the case is only on exceptions to return or on whether or not the child is settled in its new environment. If parties don't raise an obvious exception, then you should raise it. Otherwise, it's likely to be raised at trial and necessitate an adjournment. Returning to my earlier comment that respondents will often be represented by professionals who are not familiar with the jurisprudence pertaining to the 1980 Convention, an example would be that they would make out an exception to return for one of 3 children, say, on the basis that the oldest child objects to return. There automatically arises an exception that may pertain to the two younger children, in that it would be intolerable for them to be separated from their older sibling who would be permitted to stay in Peru. Make clear to the applicant that you require detailed orders about the return of the child, that is, flight dates, who's going to pay, where the child will be, who will take the child to the airport, and who is able to travel with the child. It's not always the best idea to have the left behind parent or a family member fly to Peru to take the child home again. But this is something that the parties need to think of well before the final decision is delivered. Ask the parties to consent to you raising any matter to do with the home state via direct judicial communication through the international network of judges, and note any consent in that order. If remote evidence is contemplated in your case, ensure that the parties know what is required to prepare their witnesses to give remote evidence. Also make sure that you are not requiring people to give evidence at times that they would ordinarily be asleep, because that makes the assessment of the physical appearance and response time for the witnesses harder to gauge. Mediation is an accepted feature of Hague return cases, even though it's not mentioned in the 1980 Convention. There is a specialised form of mediation that pertains to Hague return cases, and it does not delay return proceedings. It is strictly a parallel proceeding. There is a guide to mediation published by the Permanent Bureau, and I commend it to you. As part of your robust case management, require parties to prepare for outcomes. Make parties state clearly what conditions to return are sought and how they are to be implemented. Consider the specialised Hague mediation through specialist organisations such as Reunite in the United Kingdom. They mediate matters that don't even involve the United Kingdom and are certainly worth contacting. I explained to the parties as part of the case management process that when a party wins, they generally know what to do, but when a losing party doesn't have a backup plan, it is the child who suffers from uncertainty. It is the child that doesn't know when they will ever see the left behind parent again, their home, their pets, their friends. And you owe it to the children, or stress to the parents that they owe it to the child or children concerned to have a backup plan, even if they don't want to face the possibility of losing the proceedings. I would have to say that the parents involved in Hague Convention proceedings are the most polarised parents that I come across in my work as a judge. I've considered with you, or asked you to consider, the enforceability of conditions to return, and that is very important. But there is, of course, the general proposition of having to enforce a return order. Some jurisdictions have difficulty with enforcing return orders, which renders the entire process futile. If Peru has a difficulty with the enforcement of orders, I'd like to hear about it in our question and answer time later on. Remember that return is actually return to the requesting state. It's not a return of the child to the left behind parent who seeks the return, or to the place within the requesting state at which the child used to reside. Depending on how the 1980 Convention is implemented in a contracting state, the prompt and mandatory return can be softened by imposing conditions to return. As I've said, Australia's legislation permits us to impose any conditions which we think are necessary to implement the Convention. As the Convention is designed to ameliorate the negative effects of international parental child abduction, the scope of conditions can be quite wide. But please be careful with them. Please do not make conditions which are so difficult to comply with that the return order is defeated. Conditions should only operate until the courts in the state of habitual residence become regularly seized of the matter. You cannot usurp the courts in the state of habitual residence as a Hague judge who's requested to make a return order. Conditions must be carefully thought through and not overdone. Don't use undertakings. Undertaking has a number of different meanings through the Hague world. Even as between common law countries, undertakings are highly problematic because of failure to comply goes unsanctioned. I recommend that you use preconditions to return. That means that you set out a condition, and if it is not met, the child will not be returned. If an exception is made out, the court has a discretion to refuse return. The 1980 Convention does not specify what informs the exercise of discretion to refuse a return. However, it is clear that the best interests of the particular child in that application are relevant at this stage in the proceedings. Can I say something briefly about the central authorities? The Australian Central Authority is responsible for administering the 1980 Convention. Yours will be too. The role of the Australian Central Authority includes prosecuting return applications through delegation to state central authorities in each state and territory of Australia. A left-behind parent is a witness, not a party, in the return proceeding in Australia. The Australian Central Authority does not charge the left-behind parent for the costs of the prosecution. The Australian Central Authority is part of our Attorney General's portfolio, and it consults Australia's network judges in relation to law reform and implementation of the Convention. Part of our recent law reform is to provide funding to respondent-taking parents so they may be represented in court. We have also amended legislation to make it easier for the interests of a child to be represented in court and to encourage specialised mediation. The legislation also contemplates conditions to return which would protect a taking parent who has allegedly been subjected to domestic violence or domestic abuse in the state of habitual residence. It is contemplated that network judges in Australia assist in training children's lawyers and specialised Hague mediators. I've already mentioned to you the Hague network of judges. Well, here we are in Australia. That's me, that's my Chief Justice, who is a Hague network judge. There we are, there's the photo. Going back to the network of judges. Any contracting state, and indeed states who've not even signed or resolved to definitely adopt the Convention, could designate judges to the International Hague Network of Judges. You can press on the link to find that there's 100 Hague network judges around the world. Network judges communicate with one another pursuant to strict guidelines to facilitate the application of the conventions, including the 1980 conventions. They must be sitting judges with experience in Hague matters and currently hear Hague matters. Every contracting state should have one or more network judges. The network judge and the central authority should try to develop a good working relationship. In Australia, we have joint education and training sessions, as I've mentioned. Recently, my colleague and I attended a conference of all of the state central authorities and assisted with presentations. It was very valuable to share perspectives. It's important when you're dealing with a Hague Convention case to consider an order for communication or access between the children and the left-behind parent. For example, scheduled video calls. This can be done on the first day in court. This is not access as is provided for in Article 21 of the 1980 Convention. It is access that would be ordered pursuant to your domestic legislation, or if you're fortunate enough to have the 1996 Convention, pursuant to Article 11 of that Convention. The reason for this is that the reason that access should be considered at an early time is that the child who has been abducted is usually completely isolated from the left-behind parent, and my experience is that the child is relieved to be allowed to have some structured contact with the left-behind parent. Communication or access for the child frequently reduces the apprehensions of all parties, including the child. This access must, of course, be exercised without the taking parent or their agent being present. The child should be accorded privacy. I commend to you the Permanent Bureau's Guide to Good Practice for Central Authorities under the 1980 Convention. Another text which I rely upon heavily is the International Movement of Children. And then there are those texts which are published by the Permanent Bureau, and many of them appear in Spanish. Thank you for listening to me. Thank you for allowing me to talk. I look forward to any questions that you have, if there is time for question and answers. And of course, I'm available to be contacted by your Hague Network judge in relation to any 1980 matters.